I walked out of a prison gate on a Tuesday morning in October, in the rain, 6 years after a jury decided, on the strength of one gas can and one shaky witness, that I had burned my neighbor's house down with him inside it. I want to tell you, before anything else, that I didn't do it. I know that's what every guilty man says too, so I'm not going to ask you to simply take my word for it. I'm going to tell you exactly how it happened, exactly how the system got it wrong, and exactly what I found out afterward that the courtroom never did. By the end of this, I think you'll understand why I was wrongfully convicted isn't even the part of this story that still keeps me up at night. My name doesn't matter as much as the shape of what happened to me. So let's start with the night that ended my old life. I was 29, living in a small town where I'd grown up, running a modest landscaping business that mostly served my own neighborhood. My closest neighbor was a man named Walter Higgins, 71 years old, wealthy in the quiet, old money way small town's produce, the owner of a large stretch of land that bordered my family's property on the eastern line. Walter and I had a dispute. I want to be honest about that up front, because it's the detail the prosecution built their entire case around, and it deserves to be said plainly rather than buried. Walter believed a section of fence separating our properties sat on his land. I believed, and had a survey from my grandfather's era to support, that it sat on mine. We'd argued about it, publicly, at a town council meeting 11 days before the fire, loud enough that half the room remembered it. I called him, in that meeting, a man who thinks money moves fence lines. It was a stupid thing to say. It was also, as it turned out, the single sentence that built the frame around the rest of my life. The fire happened on a Thursday night in March. Walter's house, a large converted farmhouse he lived in alone since his wife passed, burned for almost 2 hours before the volunteer fire department, 40 minutes out, could do much more than keep it from spreading to the tree line. Walter didn't get out. The county ruled it arson within a week, based on burn patterns their investigator read as accelerant pour marks near a rear window. And 4 days after that, 2 detectives came to my house at 6 in the morning with a warrant and found a red plastic gas can in the bed of my landscaping truck, a truck I kept unlocked, parked in my own driveway, because I'd never once in my life had a reason to lock it. I told them, that morning and every morning after, that the can wasn't mine. I own gas cans. Every landscaper does, but not that one, and not in that spot. I kept mine in a locked shed, and I could account for every one of them. Nobody believed me, because why would a stranger plant a gas can in an unlocked truck bed in a town where nothing ever happens? The simplest explanation is usually the right one, and the simplest explanation, to everyone but me, was that the angry neighbor from the town meeting had done exactly what angry neighbors in stories like this always do. Then came Marlene Boyd. Marlene lived 2 houses down from Walter, on the other side from mine. She testified that she'd seen my truck. She was specific about the color, a faded green, distinctive enough in town that it wasn't a stretch to believe her, parked near Walter's property line around 11 that night, roughly 90 minutes before the fire department got the call. She said she recognized it because she'd been up with a sick dog, glancing out her kitchen window. It was thin, it was dark and far, and she admitted on cross-examination she couldn't see who was driving, or confirm the license plate, or say with certainty it wasn't some other faded green truck in a town with more than a few of them. But juries don't weigh probability the way they should. They weigh a story, and the story the prosecution told was clean. Angry man, public dispute, gas can, truck sighting, and a body. My public defender, a decent man badly overloaded with 60 other cases, did not have the time or the funding to hire an independent fire investigator to challenge the accelerant findings, and the county's investigator was allowed to stand up and describe burn patterns as though arson science in a small county courtroom were as settled and precise as DNA. It is not. I would spend years learning exactly how not settled it is. The jury took 4 hours. I remember sitting at the defense table watching the clock on the back wall, certain that a long deliberation meant doubt, meant someone in that room was fighting for me. I've since learned that's not how it works. 4 hours can just as easily mean 12 people quietly agreeing and taking their time being polite about it. When the foreperson read the verdict, I did not react the way I'd always imagined an innocent man would. I didn't shout. I didn't collapse. I sat very still, the way you do when a car is sliding on ice and some animal part of your brain has decided that stillness is the only thing left within your control. I was 30 when the judge handed down the sentence, 22 years, with the possibility of parole after 14. I remember almost nothing else about that day, except the sound my mother made when the verdict was read, a sound I still hear sometimes in rooms that are otherwise completely silent. And I remember, as they walked me out in restraints, catching one last look at the gallery, and seeing, 3 rows back, a face I registered only as vaguely familiar and immediately forgot. It would be 6 years before I understood why I should have looked at that face longer. I'm not going to walk you through all 6 years, because most of prison is not a story, it's just time, day folded flat on top of day, until you stop being able to tell 1 month from the last. I will tell you the 2 things that mattered, because without them, I don't think I'd have walked out of that gate at all. The first was a man named Otis, 64 years old, doing a life sentence for something he'd actually done decades earlier and had long since made a kind of exhausted peace with. I met him in my 2nd month, in the cafeteria, when I was still moving through my days like a man underwater, and he sat down across from me without asking and said, "You're the fire," not a question, just a fact he'd apparently already filed away about me. I didn't answer. He kept eating. Then he said, "You keep telling everybody you're innocent. Nobody in here cares. What you should be doing is reading." Otis had spent 15 of his years in that facility working in the law library, and he had watched enough other men's cases, some real, most not, to develop a strange, patient expertise in exactly the kind of forensic failures that had convicted me. It took me almost a year to trust him enough to actually take his advice, a year I now consider close to wasted, spent instead writing angry letters to a public defender's office that had already moved on to 60 other cases. When I finally did start showing up at the library, Otis didn't hand me answers. He handed me a stack of appellate case summaries and told me to find the ones that sounded like mine. It took me weeks of squinting at legal language I didn't understand to find the phrase that changed everything. He was the one who first said the words negative corpus to me, a term for exactly the kind of reasoning that had put me there. An investigator, unable to identify a specific accidental cause for a fire, defaulting to arson simply because they couldn't rule it out, rather than because they could prove it. He told me, flatly, in the law library on a Tuesday, I still remember clearly, "Your case wasn't proven. It was assumed. There's a difference, and there are people outside who spend their whole careers on that difference. You need to find them." I asked him once, months later, why he was helping me. He shrugged and said something I've never fully stopped thinking about. "I did what they said I did. I'm not getting out of here, and I've made my peace with that. But I've watched maybe a dozen men come through this library who didn't do what they said, and most of them gave up before they found the sentence that would have saved them. I can't undo mine. I can maybe help somebody find theirs." He never once asked me for anything in return, and in 6 years, he never once brought it up again, as though the offer itself had been the entire transaction. The years themselves I'll spare you the texture of, because texture isn't really the right word for something that flattens rather than deepens. I'll tell you about one day instead of all of them. In my 4th year, my mother had a stroke. I was allowed a single supervised visit to see her in the hospital, in restraints, for 11 minutes, with a guard standing close enough to hear every word. She could barely speak. I remember trying to tell her I was going to fix this, and watching her try to form a response with half her face working and understanding in that hospital room that I might run out of time to actually keep that promise to her. I went back to my cell that night, and I did not sleep, and in the morning I went back to the law library, because it was the only lever I had left, and Otis was already there, and he didn't ask how the visit went. He just slid a new folder of case summaries across the table. The second thing that mattered was that I believed him enough to spend the next 4 years writing letters. Dozens of them, to every wrongful conviction organization I could find addresses for, most of which never answered, a few of which sent form letters explaining they had a 3-year backlog. I kept writing anyway, because Otis had taught me the other thing prison teaches you if you let it, which is that patience isn't a virtue in a place like that. It's a survival skill, the only lever you have left when every other lever has been taken from you. In my 4th year, a small nonprofit out of the state capital, 3 lawyers, and a rotating group of law students took my case. It took them another 2 years to do it properly. They found a retired fire investigator, a man who'd spent 30 years doing the job the county investigator had done for 8, and he re-examined the original photographs and reports and found exactly what Otis had predicted years earlier in a prison library. The pour pattern the original investigator described near the rear window was consistent, in the retired investigator's professional opinion, with what's called flashover, a point where an ordinary accidental fire, fed by old wire in the county's own record showed Walter had been warned about 18 months earlier and never fixed, becomes so hot that it produces burn patterns that untrained or outdated investigators frequently misread as accelerant use. It is one of the most well-documented sources of wrongful arson convictions in the country, and my county's investigator, God rest whatever certainty he still carries about it, had never been trained in the updated science. That alone might have been enough, eventually, for an appeal. What broke the case open faster was Marlene Boyd, the nonprofit's investigator, doing the unglamorous work nobody had bothered to do 6 years earlier. Went and actually talked to her. Not in a courtroom, just on her porch, gently, the way you talk to someone you're not trying to trap. And Marlene, 5 years older and, I think, 5 years heavier with something she'd been carrying, told a different story than the one she'd sworn under oath. She said she hadn't been entirely sure what she'd seen that night. She said someone had encouraged her, gently and repeatedly in the weeks after the fire, to be more certain than she actually was. Someone who told her would help put this whole thing to rest for the town. Someone who'd helped her out with a plumbing bill around the same time she gave her final statement to police. A coincidence. She said she'd never let herself examine too closely because it was easier not to. She wouldn't, even then, name the person outright. But she gave a description, and the description was not a stranger. Before any of that reached a courtroom, there were 2 more years of rejected filings I haven't mentioned. A first appeal denied on a technicality neither Otis nor I fully understood until a law student explained it to me in words simple enough to actually land. A second filing that sat, unanswered, for 11 months while I taught myself not to check the mail slot with my whole chest every single day. I mention this because I don't want you to picture this as one clean break in the case, followed by a swift release. It was 3 separate near misses before the 4th attempt finally held. The hearing itself, when it finally came, lasted less than 40 minutes, which felt almost insulting after 6 years, like watching a house burn down in a photograph instead of in real time. The retired fire investigator testified for maybe 12 of those minutes, walking the judge through the flashover findings with a patience I recognized immediately, because it was the same patience Otis had once used on me in a prison library. Marlene did not appear in person. Her recantation was submitted in writing, at her own request, and I understood, watching the judge read it silently at the bench, that some kinds of courage only extend as far as a signature. The judge, an older man who had not presided over my original trial, read his ruling in a flat, procedural voice that gave away nothing of what he might have privately thought about a system that had taken 6 years to say 4 sentences. My conviction was vacated 14 months after the nonprofit first found the flashover evidence, on the combined weight of the new fire science and Marlene's recantation. I walked out of that gate in the rain, 36 years old, 6 years gone, to a county that officially closed my case as insufficient evidence to sustain conviction. No new suspect named, no explanation offered for the gas can, just a door, an apology nobody in an official capacity actually gave me, and a life that had kept moving without me while I stood still. I want to tell you honestly what those 6 years cost, because it matters to the rest of this. My mother, the stroke I mentioned, never fully regained the speech she'd had before. Every phone call with her now is slower, more patient, and I try, most days, not to let her hear how much that still breaks something in me. My fiancée, Sarah, stayed for 2 years. She visited every other Sunday for the first 18 months, brought me photographs of a life that was moving forward without me, and never once in all that time said a cruel word to me. She simply ran, eventually, into the plain math of it. She was 28, and I might realistically be 60 before I saw the outside of that facility again, and no version of loyalty is built to survive a number like that indefinitely. The last time I saw her, in the visiting room, she held both my hands across the table and said, "I need you to know this isn't about whether I believe you. I do believe you. I just can't keep waiting for a door that might never open." I told her I understood. I did understand. It still took me another year to stop reaching for her side of the bed in a cell that didn't have a bed built for 2 people to begin with. My business was gone within the first year, the truck sold, the equipment scattered. I came out to a small settlement, checked the state, eventually offered. The kind of number that sounds large in a headline and evaporates the moment you try to rebuild an actual life with it. And a version of my hometown that had spent 6 years being told and believing that I was the kind of man who burns his elderly neighbor alive over a fence line. I want you to understand that I could have taken the door. Most people, I think, would have. Insufficient evidence, a small settlement, a fresh start somewhere and nobody knew my name. I tried that. I moved 3 states away, took a job doing groundskeeping for a property management company under a version of my name I didn't bother correcting when they misspelled it on the first paycheck, rented a small apartment, and told myself every morning for 4 months that this was the beginning of the rest of my life. It might have worked, eventually, for a different kind of man. For me, it kept collapsing in small, specific ways. I'd be raking a lawn on a Tuesday afternoon and catch myself doing the thing I'd done every day in that cell. Running the timeline of the fire, the gas can, Marlene's testimony, searching for the crack in it I still hadn't found, and I'd realize I'd been standing motionless with a rake in my hands for I don't know how long. I lasted 4 months in that quieter room before I understood I wasn't actually building anything new. I was just carrying the same weight somewhere nobody could see me carrying it. Because here's what insufficient evidence doesn't tell you, and what nobody in that courtroom seemed interested in solving now that I was no longer a convenient answer. Somebody set that fire. Walter Higgins was 71 years old and burned to death in his own home. And whoever did that walked past a jury, past 6 years of headlines about my guilt, and out the other side completely clean, because the system had already found its man, and systems, once they found their man, rarely go looking for a second one. And somebody planted a gas can in my truck, and somebody, Marlene's description made this very clear to me the moment the nonprofit investigator read it to me over the phone, had gently, patiently, helped a lonely widow become more certain of a lie than she actually was. I went back to Otis's advice, the same patience he'd taught me in a law library, and I started where the actual investigation should have started 6 years earlier, with who benefited from Walter Higgins being dead. Walter had one living relative actively involved in his affairs, not a son or daughter, but a cousin, 12 years younger, named Grant Marsh, who had managed Walter's finances and land holdings for almost a decade. I remembered Grant vaguely from before all of this, a quiet, capable, unremarkable man who handled Walter's paperwork and occasionally waved to me across the property line. I had never once, in 6 years of turning this case over in a cell, given him a serious thought, because the prosecution never had either. He wasn't in the story. That, I would come to understand, had been the entire point. I spent 3 months using the small settlement money in a way I think Otis would have approved of, doing the quiet, patient legwork nobody had done. I started at the county courthouse, in a records room I'd never once had a reason to visit before all of this, requesting every public probate filing connected to Walter's estate, filings that had sat frozen for years while the criminal case against me worked its way through appeals, since an estate can't fully settle while a related conviction is still active. What I found in my first week alone was that Grant had been granted broad power of attorney over Walter's finances 2 years before the fire, as Walter's eyesight and memory had started to fail, a fact that had never once come up at my trial because nobody on my defense side had thought to look for it, and nobody on the prosecution side had any reason to want it found. I am not a financial investigator. I spent most of that first month simply teaching myself to read the documents I was pulling, sitting at my kitchen table with library books on forensic accounting, cross-referencing account numbers by hand on legal pads the way Otis had taught me to work through case law, slowly, methodically, assuming nothing until the paper actually said it. By the time I brought what I had to a forensic accountant, the nonprofit connected me with a quiet, precise man named Alvarez, working at a steep discount because he'd read about my case and, in his words, wanted to see if the math agreed with you. I already had enough of a shape that it took him only 2 weeks to confirm it formally. What his full report showed was a pattern of transfers out of Walter's accounts into shell entities that traced back, 3 and 4 layers deep, to Grant Marsh. Just over $400,000, moved in small, careful increments over 18 months, the kind of amount and pacing specifically designed not to trigger the attention of a bank compliance officer. Alvarez put to me plainly, tapping the printed report on my kitchen table. Whoever did this understood exactly where the reporting thresholds sit. This isn't a man who panicked and took money. This is a man who planned a withdrawal schedule. I want you to sit with the timeline the way I had to. Grant had been quietly draining his cousin's accounts for a year and a half. And the fire happened 3 weeks after Walter's longtime accountant, a semi-retired man named Phillips, who I eventually tracked down and spoke with myself, had called Walter to schedule what Phillips described, in a conversation I recorded with his permission, as a full review, because some of the numbers on the recent statements didn't sit right with him. Walter, according to Phillips, had sounded rattled on that call. Walter died 17 days after that call was scheduled, in a fire that investigators originally attributed to a stranger with a grudge over a fence line. The one person in town, thanks to a town council meeting 11 days earlier, who made an almost effortlessly convenient suspect. I don't know, and will probably never know with total certainty, whether Grant set that fire to destroy financial records he knew were about to be reviewed, or to silence a cousin who was about to discover he'd been robbed, or both. What I do know, because the forensic accountant's report and Phillips's testimony together made it plain, is that Grant had both a motive and roughly 3 weeks of urgent pressure that nobody else in this story had. The last piece I needed, I decided, had to come from Marlene herself, in person, not through the nonprofit's investigator this time, but from me directly. I think I needed, after 6 years, to hear in my own hearing rather than secondhand. I found her at the same diner she'd apparently been going to every Sunday morning for as long as anyone in town could remember, and I sat down across from her without an appointment, the way Otis had once sat down across from me. She went pale when she recognized me. I told her I wasn't there to be angry at her, which was mostly true, and I asked her to just tell me what actually happened, plainly, one time, and then I'd leave her alone. She was quiet for a long moment, turning her coffee cup slowly on its saucer. Then she said, "I really did see a truck that night. I want you to know that part was never a lie. But it was dark, and it was far, and I was scared because a man had just died 2 houses down from me. And about a week after, a man came to my door, kind, soft-spoken, said he was helping settle Walter's affairs. And he sat right where you're sitting, and he asked me, so gently, whether I was certain it had been your truck. And every time I said, I think so, he'd nod and ask again a different way, until somewhere in there, I actually started to feel certain, like the certainty had always been mine, and he just helped me find it." She looked up at me then, and her eyes were wet. "He fixed my plumbing that same week, paid the contractor himself, said it was just neighborly. I told myself for 6 years those two things had nothing to do with each other, because it was easier than the alternative. She gave me his name herself, before I even asked. It was Grant Marsh. I'm so sorry. I've known it was probably him for a long time. I just didn't know how to undo 6 years of being sure. I took all of it, the financial trail, Phillips's recorded account of the scheduled review, and Marlene's full signed, notarized new statement. Not to a lawyer first, but to the original lead detective on my case, a woman named Detective Reyes, who I'd spent 6 years hating in the abstract, in the careful, permanent way you hate a name attached to a file rather than an actual person. I expected, walking into that station, to have to fight her for every inch. Instead, she sat across an interview room table from me, read through the folder I'd built for almost 45 minutes without saying a word, and then closed it and looked at me with an expression I hadn't been prepared for, which was something closer to exhaustion than defensiveness. She told me something I've thought about often since. She said, "We had a story that fit. We stopped looking the moment it fit. That's not an excuse. It's just what happened, and I'm sorry it happened to you specifically." I asked her because I could not ask whether she remembered Grant Marsh from the original investigation at all. She was quiet for a moment, and then she said, "He was cooperative, grieving cousin, handled the paperwork, answered every question we had. People like that don't usually make our list. That's exactly why people like that are good at this. It wasn't the apology the county owed me on paper. It was, I think, the only honest one I actually got, and I believed her more for its plainness than I would have believed anything more polished." Grant Marsh was arrested 11 weeks later. I wasn't there for the arrest itself, but Detective Reyes, in a gesture I still don't fully know how to categorize, called me the following morning to let me know it had happened before I could hear it secondhand around town. I sat in the courtroom for his arraignment 2 days after that. A courtroom in the same building where I'd once stood and heard 4 hours of deliberation in my old life. And I watched him enter a plea of not guilty in a voice far less confident than the one I remembered from waving hello across a fence line for years. He looked smaller than I remembered. I don't know if that was the fluorescent light, or the restraints, or simply the particular way a person shrinks once the story they've been telling everyone, including themselves, finally runs out of room. He looked back at me once, across the gallery, for maybe 2 seconds. I didn't look away. He did. His trial, as I write this, is still pending, charged with murder, arson, and financial fraud connected to Walter's estate. I understand if that feels like an unsatisfying place to end story. It is. I've had to make peace with the fact that some doors take longer to close than others, and that the version of justice available to me now is slower and less cinematic than the version that was so efficiently, wrongly delivered to me 6 years ago in 4 hours flat. I've started attending every pretrial hearing I'm permitted to sit in the same seat, 3 rows back on the aisle. The same seat I realized only after the 3rd hearing, where I'd once glimpsed an unfamiliar face I couldn't place on the day I was sentenced. I understand now exactly why I couldn't place it. I'd only ever seen Grant from a distance, across a fence line, waving. People ask me, sometimes, if I feel like I won. I don't. Not in the way the word usually means. Winning would have been Walter alive. My mother's stroke never happening in a hospital hallway. I could only watch through restraints. Sarah still beside me. 6 years of an ordinary, unremarkable life I'll never get any version of back. What I have instead is something smaller and, I've come to believe, still worth having. I have the actual truth, finally sitting in the actual place it belongs, instead of quietly living rent-free in an unlocked truck bed and a frightened widow's borrowed certainty. I have Detective Reyes's honest sentence instead of the county's bloodless, insufficient evidence. And I have 6 years of practice patience that I would give anything not to have had to learn, but that I used, in the end, for exactly the one thing it turned out to be good for. I called Otis last month, the one phone call a year the facility allows him with someone outside his immediate family. A privilege I had to fill out 3 separate forms to be added to. I told him about Grant's arraignment, about Marlene's diner confession, about Detective Reyes closing the file folder and calling it what it was. He was quiet for a moment on the line, and then he said, in the same flat, patient voice he'd used across that library table years earlier, "See, that's the difference. Assumed cases fall apart, proven ones hold." I asked him if he ever regretted teaching a stranger how to do the thing that was going to walk out the door he never would. He laughed, actually laughed for the first time I think I'd ever heard from him, and said, "Son, that was never about me getting anything back. Go live something worth the years it cost you." I haven't stopped thinking about that sentence since. I visited my mother 2 weekends ago. Her speech is still slow, still effortful, but she managed this time to get through an entire sentence without needing to stop and rest partway through, which the doctor tells me is real progress, and which felt, to me, sitting across her kitchen table, like the first entirely unqualified good thing that had happened to either of us in 7 years. I didn't tell her about the arraignment. Some doors, I've decided, are mine alone to walk through for a while longer. It's raining tonight, the same steady, ordinary rain that was falling the morning I walked out of that gate. I think about Otis sometimes, still inside, still teaching some other frightened man in a law library the difference between a case that's proven and a case that's merely assumed. I think about Walter, who I argued with over a fence line 11 days before he died, and who deserved a system that looked past the easiest answer instead of stopping the moment it found one. And I think about the particular, specific weight of being told, for 6 years, by every official voice with the authority to say it, that you are exactly the worst thing you know yourself not to be. If there's one thing I want you to take from this, it isn't really about fire, or fences, or even about Grant Marsh, whatever a jury eventually decides about him. It's this. The easiest answer is not the same thing as the true one. 6 years of my life were spent inside that difference. I hope you never have to learn the way I did. But if you're ever the person sitting in the jury box, holding someone else's whole life in a story that simply fits a little too cleanly, I hope you remember that insufficient evidence and the truth are not always the same door, and that somebody, somewhere, might still be waiting on the other side of the real one.